here. Nelson Mandela quotes, to deny people their rights is to challenge their very humanity. I, Dr. Sadaf Khan, on behalf of entire faculty of welcome you all in this 14 days international faculty development program on changing of human rights in a globalized world. Eighth technical session of ethics is dealing with judicial contemplation of human rights in human rights are owned by states or individuals within their jurisdiction, and in some situations also to groups of individuals. The principle of universal and inalienable rights of all human beings is thus solidly forged in international human rights law, as well as the human rights law of the respective states. That the essentials of man are not derived from one's being a national of a certain state, but attributes of the human personality. In emergency situations, the rights protected by these laws cannot per se be suspended even in emergency situations because they are inherent to man in the view of the various judgments of the court that what be suspended or limited as under the convention is the full and effective exercise of the rights contained therein. As the African Charter on Human and People's Rights mentions that fundamental rights stem from the attributes of human beings, which justifies their national and international protection. To deal with this manner judicially, we have our honorable resource person, Dr. Aditya Pratap Singh. Dr. Aditya Pratap Singh has done MA in linguistics besides LLB, LLM, and LLD. He has been a JRF awardee in law and is working on semiotic analysis of the basic structure and feature of the Indian Constitution. He has been a visiting faculty in Department of Linguistics, Lucknow University, and guest faculty in Applied Linguistics in Mahatma Gandhi International Hindi University, Wardha, at its Bhasha Kendra, Lucknow. Dr. Singh was resource person in IPR in Lucknow University LLB honors course. He served in MMH College, Ghaziabad, in the capacity of a permanent faculty in law. Mr. Singh specialized in British constitutional law, criminal law, semiotics, semantics, conceptual linguistics, and media law. Welcome, sir.
Thank you. Thank you, madam.
Enlighten us with your thought-provoking lecture, sir. Over to you, sir.
Thank you. Thank you. Thank you, Dr. Sadaf, Dr. Siddiqui, other honorable faculties, your Vice Chancellor, Director, and team. The topic that you have allotted me for the session is judicial contemplation of human rights in contemporary world. Now, since this is a faculty development program, I would be speaking and beginning with a few issues that concern the academia today, particularly in our system. And then I'll be gradually moving to the topic. First one is that I hope that most of those attending this FDP are people from academia and research scholars and many others who are likely to join the profession. What actually is the quantum and people from which disciplines they are drawn here, I'm not having the complete figure and data, but I hope that people from these areas are in the development program. First one is that FDPs, what is the target of FDPs? Why FDPs? In last 30 years, if you begin the practice from 1990 till date, 2021, roughly in the last 31 years, more than 3 decades, our institutions are working with faculty development programs. And these development programs, they basically involve number one, orientation course, second, refresher courses, and the third one, week long or fortnight long other courses, uh, typically given to these subject areas in which different departments and faculties are working. So if I ask that in last 3 decades, whether our academic staff colleges at all levels, from central universities to IITs to IIMs, in last 31 years, the composition of the pedagogy of teaching and learning and updating the people in the academia in these decades, whether it has got changed with the time, whether it has evolved with time or not. So the first picture that comes to us, that nature of academic staff colleges dealing in particularly faculty development and enrichment programs in last 31 years, we have no other idea except that orientation courses and refresher courses with some senior faculty members addressing the young academia. In terms of technology, in terms of many other developments of teaching and learning, pedagogy, teaching from the point of view teacher, what should be the method of teaching, and learning from the point of view of those who are sitting in the class, the students. There are two different pedagogies, uh, how a teacher should teach and how a student can learn. Technology has intervened at both these levels. The teaching tools are now changed with technology, and learning tools are also changed. This first issue. Second one, that the intervention of technology has changed the aspect, interaction, and what we call the closeness of discussion and involvement. That is changed. So, say for example, about a decade before, if you recall, nowadays the culture is changing in last 4 or 5 years, and with the last pandemic year, it is totally changed. Our institutions had a very different view about students having laptops or mobiles in the classroom. They were not ready to accept this fact that students can at the same time open and search in the browser what the teacher is addressing. This kind of liberty was not there. For a teacher, this liberty to be accepted and for the students, that this liberty and freedom to them to be given a couple of years before, 2, 3 years before, it was not permitted in the best of the institutions at national level. So now, if FDPs are to be designed, the first is that how we can uh, tell our academia, people who have just joined or likely to join, they are somewhere in the starting years of joining academy. What ideas, what fundamental prejudices we should shed off is that intervention of technology should be accepted and allowed. Gone are the days when students looked at the faces and the dressing sense of the faculty member in class. अब वो वक्त नहीं रह गया है कि टीचर क्या पहन के आया है, टी शर्ट पहन के आया है या हाफ पैंट में आया है या टॉवेल लपेट के आया है. This now this I mean interaction, personal interaction and observation, looking at the face, the grace, the dignity, the style, the panache, and what we call the swag of the teacher, that is gone. So the challenge before our new academia is that how to interact more closely with the students. And in this area, we are lacking thoroughly in the sense that uh, our culture is still uh, in a very evolutionary, rudimentary, primitive form. So the first address and appeal to the people who have just joined academia, that please do accept these technological interventions. So we have changed the way we interact with our students today. Uh, I recall my period in Raman or Loya, that when I joined in 2006, I allowed my students all kind of liberties: phones, tablets, laptops, everything. That while I am teaching, you can check, you can update yourself with more facts and figures on what I am interacting. So the first address to academia, young academia, that please do allow these changes. Only then we are going to make a little change in our teaching pedagogy and learning pedagogy. Now, the second issue, that is the topic of the session today: judicial contemplation of human rights in contemporary world. Suppose that this topic has to be uh, thoroughly hacked. Let us look into this topic. So what this topic actually means, meaning is very important. And when a teacher is clear about the meaning, only then the communication of that is possible to the audience, to the students. This topic involves many expressions, many concepts. One is the judicial contemplation. Contemplation is a thinking process. So whether our courts, while deliberating upon, while addressing the human rights at the forum, they are in the contemplation mode or not. What is the outcome of that contemplation? judicial contemplation, judicial thinking, the product of that thinking, in particularly human rights issues, and in a contemporary world. So, world includes our national forum, world includes the other legal systems and cultures. So, first issue I will like to uh, explore more deeply. If I put before you a question, and that too in domestic and national perspective, and the same is at international forum, whether if you are before a European Court of Justice, if you are in an American court, or for that matter, any other national court, or international courts and tribunals. If the question is whether the forum, the people who are donning the position at specific fora, they are actually thinking and producing. Judicial contemplation. I mean, people sitting at the fora, they are thinking and evolving the philosophy, principles, and theories. एक सीधा सा ब्लंट सा सवाल कि हमारा सुप्रीम कोर्ट में जो या हाई कोर्ट में जो ह्यूमन राइट्स के मैटर आ रहे हैं, उसमें थ्योरी, प्रिंसिपल्स और फिलॉसफी का एवोल्यूशन करने में बेंच कितना इन्वॉल्व्ड है, बेंच का इन्वॉल्वमेंट कितना, और बेंच को कितना रिसर्च सपोर्ट मिल रहा है. कोई कंटेम्पररी इशू आ गया, समथिंग न्यू that is coming, the gender issues are there, issues of caste being there, issues of violence, other social evils, women's entry in temples, etc., etc. Many innovative themes are coming before our judicial institution. Now a judge is judge and is busy with thousands of cases every day. So if the question is that whether they are given the time to think and reflect and produce principles, theories, and philosophies upon matters for which they are paid for deciding and providing justice, क्या उनको इतना वक्त दिया जाता है कि वो सोचें, प्रिंसिपल्स को क्राफ्ट करें, मॉर्फ करें, फिलॉसफीज को नई सोच कर लाएं? एक मैकेनिकल सिस्टम है where we are citing judgments, previous judgments, and trying to provide justice on the sense that we have got from the past wisdom. पीछे जो 50 साल में डिसाइड केस है उसके साइटेशंस कुछ दिए और then the present issue to be decided on that basis. So we are not sparing, we are not actually giving our judicial institution the time which is actually required for judicial contemplation, particularly herein on human rights issues. So what is the result? The result is that there is a mechanical churning out of thousands of judgments from our courts. But if you trace any new innovative sense of wisdom in any judgment, that is missing. It is missing not because that judges are not striving and working. It is because they are not given the time, so much work pressure, and the vacancies in the judicial. The government is not interested in filling up the vacancies at judicial firm. So, for example, if you look to Uttar Pradesh, how many seats at High Court they are lying vacant? When there is so much of judicial pressure, why the government is not appointing? Because people are not there in the field. And this. So, one thing for today's discussion is that contemplation somewhere is in deep crisis today. Rather, there is a mechanical, cyclo style production of judicial relief through our judicial forum. And the same is at international tribunals also, because international tribunals, they don't, import the judges from the heaven. They are actually people drawn from domestic and national uh, fora. So once our judges retire, say for example, they go to international tribunal. Same from other legal systems. So people who are sitting in international tribunals are actually people who are trained, who are conditioned to think like at national level. So what is the end result? End result is that we have no new expressions, principles, and theories which we can call that they are actually the brainchild of the product of the judicial forum. Forget about the institution's role. I mean, the teachers, philosophers, and people in academia at Harvard, Yale, Oxford, Cambridge, those who have nothing but the time, energy, synergy to think and to evolve and to develop principles. And then these principles at these Ivy League institutions, once they are made out in the academic institutions, they are taken out, and they are the ideas on the basis of which the judicial fora is actually working on. So, the first question that whether the judicial fora is working, judges are working on their own philosophies and principles, or they have principles and theories made in the academic institutions and they simply borrow it, import it, and apply it and give it. This is the, projection and portrayal that judicial contemplation is missing. Not totally missing, but the quality contemplation is missing. One or two or three or a couple of dozen of examples don't make up the majority. So this is the state of affairs at national level and at international tribunals. That judicial contemplation is missing because judges have little time to think and evolve. And this is in regard to human rights, particularly, uh, uh, as we take up that today's topic. So, what is happening in contemporary world? It was not happening in world, say, for example, 2 or 3 centuries before. The judicial fora was there, judicial institutions were there. Say, forget about contemporary world. If you go into a world in the past 2 centuries before, there were innovations. A couple of days before, I was going through a few of my queries in a book on evidence written by Henry Cunningham in 1872. It was just a curiosity I opened because I had in the past gone through. If you open up, uh, and in this session also, I'll suggest you that please open up your browser, look for Cunningham's book on evidence. This is how we interact at national law institutions today. We are not interested in looking your faces or you my face. Uh, Face is a material. Interaction is more important. So open up your browser, look for Cunningham's book on evidence. If you look to the contents of the book, if you just scroll down the pages, you will see that this book actually runs into close to 300 pages. And if you look to any specific page, hardly there is mention of any judicial case by the learned scholar Henry Cunningham. He having mentioned no court case decided on evidence. And the preface of this book was written by Cunningham on 1st September 1872, the date of Enforcement of Evidence Act, which is presently in 300 pages of manuscript by him is totally dedicated to what philosophical issues were there in the making of Evidence Act. He has simply written 300 pages upon this without any court case in the book. Can you imagine any such book today by any author, national or global, one from the Oxford or Cambridge or Yale or Harvard? Have you seen any book without any judicial case being mentioned? Totally book given to specific legislation and the principles and theories uh, of its morphing and shaping. You will hardly find any book, any author so much dedicated to the cause. कोर्ट केस के बारे में उसने बात ही नहीं करी. उसने कहा है कि एविडेंस एक्ट में ये कॉन्सेप्ट किसके सेंस में यूज हुई है, लॉजिक क्या है, रैशनल क्या है, प्रोबेबिलिटी किसको कहते हैं, हाइपोथेसिस किसको कहते हैं. Marvelous book. So if I draw you from there, from Cunningham, which I hope that you must have explored in your browser, come to the topic of today. Whether there is any judicial contemplation about human rights by any foreign national or international in contemporary world, whether any contemplation is actually happening, the answer is so sad. Picture is clear. There is no judicial contemplation. Contemplation, whatever it today is, there is in the Ivy League institutions by some very learned people from academia. There is no judicial contemplation. There is only what we call at different national or international fora, that human rights issues that are to be taken up when it comes to judicial forum. The first effort has to be whether the prevention is possible. So, steps for preventing preemptory attempts. Then, once the violation is done, then investigate it. So, if the prevention is not possible, if the mishap having occurred, then the second, that judicial institutions and at international level or national level, therein to investigate the case properly, come up with facts, figures, and evidences. The third one is that once the investigation is done, then trial and punishment. This is the third involvement of the judicial fora at national level and international level. So they have no time to contemplate. They have only the time for once the record is put before them, portrayed to them, what they are actually supposed to do is to apply the procedure in having a fair trial and accordingly what evidences suggest punishing or acquitting the person. Then the last, what is at the end, what judicial fora is busy, that in punishment is not the end. One more task is left, that of making good to the damage which is caused. And this is by providing compensation mechanism, restitution, rehabilitation, restitutive justice, and many other, involvements of our judicial. That is what we call uh, the approach of our courts at national and international level when it is a matter of human rights. Nothing more than that. So prevent, if not investigate, have a trial, punish, and then providing restitution, rehabilitation, compensation, and nothing more than that. The contemplation is missing. So, what is the result? That nothing new in terms of wisdom coming out of national fora or international fora. That is why the people of your generation, today's generation, the generation which has just entered a couple of years before an academic, and with whom you are interacting, students of today, boys in their teenage 20s, early 20s, etc., etc. They are not interested because they fail to see any innovation in last 150 years. There is no innovation, mechanical application, nan application, no new wisdom coming. So this is one aspect of it. Second, what actually lies at the judicial forum, but which actually comes up from the wisdom, which is actually from academic institutions, that human rights issues involve, and they are basically, they cannot be separated from the culture in which they evolve. Human rights issues, they have a front and a face, which we call that they are natural, inalienable, and they can't be suspended, etc., etc. and that is their global character. But at the same time, if you look to human rights violations and human rights, actually, these violations cannot be separated from the social realities where they happen. So for example, if there is a case of manual scavenging happening in a third world country, now I suggest you, because you are younger people in academia and likely to apply for many kinds of scholarships for having 1 or 2 years spent there in Western institution, that if you are into anything that is happening in third world, for example, if you want to study in Harvard and if you have a target and a goal doing LLM or PhD or JST from Harvard or for that matter any Western institution, they won't invite you and they won't provide you funds when it comes to core principles of theory and philosophy. But the moment you pick up any topic that is a human rights violations in a third world country, for example, manual scavenging, and if you are ready to provide them the data of the third world of your nationality, of your country, as to facts and figures of manual scavenging, the Western academic institutions are very much interested in these pursuits. They will invite you with full funding. आजा भाई, तेरे पास डेटा है, मैं तो यही खोज रहा था थर्ड वर्ल्ड में कि मैनुअल स्कैवेंजिंग कहाँ हो रही है, आजा आजा, मैं तेरे को फुल फंडिंग. I mean, people of the first world, so called, they are interested for human rights violations in third world with a different set of social realities. Social realities of making livelihood, that of having employment. So if there is someone who is deeply half within a sewage tank, they are more interested in what is happening over there. ये आदमी नाली में घुस के क्या कर रहा है, हमारे यहाँ तो लोग नाली में नहीं घुसते. So the people, the academic institution, the scholars, philosophers in the first world and their academic institution, they are interested in knowing the human rights issues happening in third world countries. Though they have their different set of human rights issues in their own culture in the first world itself, but they are not, I mean, they are least interested in the human rights issues happening in their own systems. So the first world academic institutions, they are least interested in knowing and providing any solution to human rights violations in their own land, in their own system, in their own society. But they are deeply interested in what is happening in third world. So yesterday, in the morning hours, I having posted an issue in my Facebook wall, which you can, it is for public view, and I quote you few lines. I write on social media, particularly Hindi, and I take few lines from there to tell you what exactly is the human rights issue. कुछ लोग गांव की संवेदना को शहर की भाषा में व्यक्त करना चाहते हैं, और कुछ लोग शहर की संवेदना को गांव की भाषा में व्यक्त करना चाहते हैं। ये दोनों ही अभिव्यक्ति के प्रश्न हैं बेसिकली. These are matters of expression. The rural issues, they are more into what we call the language which is alien to the rural people, and then the issues of the urban society, they are into rural languages. These two issues, these two kinds of expressions are there. So people of both the systems, people who are actually the villagers, they are interested in knowing in their own language, and people who are from urban societies, they are interested in knowing in their own language, which is quite understandable to them, which is quite palatable to them. But different kinds of expressions are coming from different people. So if you apply this, if you stretch this logic and rationale in international field, that the people of the first world and the academic institutions of the first world, they are not interested in knowing, discovering, and providing solutions to human rights violations in the first world, in their own society. Rather, they are deeply interested in what is happening in third world. शहर का आदमी गांव के बारे में जानने को इंटरेस्टेड है, और गांव का आदमी शहर के बारे में जानने को इंटरेस्टेड है. गांव का आदमी गांव के बारे में और शहर का आदमी शहर के बारे में जानने में इंटरेस्टेड नहीं है. This is happening. Now, what will be the result? Result would be this, that if you are providing a data of the third world country, and if you are studying in a first world academic institution, say for example, any Ivy League university, if you are providing data on human rights violations of a specific society, they are into writing dissertations, doing PhD works, then they make out of this whole mess, they produce theories. Then these theories and principles and philosophies, they are exported to judicial fora where judges apply these things, because they have no time for their own contemplation and thinking. So they are importing data from academic institutions, and academic institutions are importing data, getting it separated from the society where it is happening. So what they get, whether they get the truthful picture, to what extent it is truthful, कितना वो सही है, they are more interested in discovering the slum dogs. So the theories which are made in the Ivy League institution, if you say that these theories are actually on the basis of real empirical data, which is closely evaluated and appreciated in terms of the society where human rights violations are happening, you will see that somewhere what is twisted and distorted is the truth. And if the truth is distorted, then any research which is the product of this empirical data, will produce a meaningless philosophy, principle, and theory. And then this distorted principle and theory and philosophy will be exported to judicial fora, and judicial fora will apply it without any time being given to this. This happens. This is the reality of human rights. Because you see that judicial contemplation of human rights in consideration. Now, incidentally, if I take you to the back side of the curtains, on the other side of the smoke screen, when I take you to the backdrop of what I have spoken, actually, I have spoken about the semiotics. Semiotics means there are many questions which you need to prepare a list of when you are exploring truth. Now, semiotics is usually taught in linguistics, not in law, at least in India. But this is not the case in the, Ivy League institution, so-called, at least top one, the University College of London, Harvard, or New York, or Massachusetts, or Oxford. The Western institutions, academic institutions, they are providing you with more deeper insights into how to explore the truth. And truth can be explored by specific tools. And tools are lying elsewhere. So if a tool is lying in Department of Linguistics, that of how to look at the truth, and if you are in law, and if you are not taught about semiotics as a tool of legal interpretation or textual interpretation, what is missing is this, that you are an average performer. That is why our law schools are from 86 onwards, the time when the first effort was made for a national law school. Till date, more than 25 national law universities. Everyone is, trying to portray itself, trying to flaunt itself as we are the best. हिंदुस्तान में देखिए तो जिस भी नेशनल लॉ स्कूल में चले जाइए तो अपने को बेस्ट कहता है. नाम नहीं लूंगा कौन कौन अपने को बेस्ट कहता है, बट हर आदमी अपने को बेस्ट कहता है. लोहिया वाले अपने को बेस्ट कहते हैं, बेंगलोर वाले अपने को बेस्ट कहते हैं, कोलकाता वाले अपने को, दिल्ली वाले अपने को, मुंबई वाले अपने को. कोई किसी को कम मानने को नहीं तैयार है. किसी के फोरम पे जाके पूछोगे हु इज द बेस्ट, कहेंगे बेस्ट तो हम ही है, बाकी दूसरे. So law schools, they fail to match to the law schools in the West, because there you have more choice of subjects, more choice of seminar papers, more choice of interdisciplinary studies. And when this is possible, only then we are going to produce some new genre, some new generation of lawyers and judges. So the task before our institution is that the new generation of lawyers and judges, because once they work here for several decades in national institutions, they will tomorrow don the international tribunals, where there are human rights issues in contemporary world of the future times. This is what is happening, and mm, this was my little interaction and portrayal, my interaction with youth people in this program. Now, I will take permission for wrapping up, and I'm thankful to uh, the law school where you are attending this FDP. Thank you, Seemaji. Thank you, Sadafji.
Thank you, sir. Thank you very much, sir. Sir, the session is open for the question answer.
Yes, yes,
If
definitely.
you grant, acha, sir. Thank you, sir. Sir, our student coordinator Sufyan Khan is asking: do human rights depend on culture, and what is the approach of judiciary regarding this aspect?
Mm, there are some voice drops. Can you repeat the question?
Yes, sir. Yes, sir. Do human rights depends on culture, and what is
Mm,
the approach of judiciary regarding this aspect?
okay, that's good. Human rights issues, they are matters of evolution of human society. They are directly connected with the human society and its involvement. So, all of a sudden, when you make up any act on human rights violations, the society in the same tone, in the same night, the day when the legislation is brought into force, it is not going to change. It will gradually change. Issues of social evils, human rights, prejudices, opinions, it takes time in changing the society. So, any human rights law which is coming, say, for example, today in the midnight, if it has to be interpreted, applied, there must be, stages of its application and enforcement and punishment and quantum of punishment. A society is full of evils, many kinds of evils, human rights, gender issues, etc., etc. So, I mean, the violations are drawn from the social facts of the life. So, judicial application of any law in a judicial fora, the justice must be delivered, keeping in regard to the slow nature of changing of society. All of a sudden, people cannot be made aware of, they cannot be expected to behave in an alien way. Gradually, the things will change. So, if human rights violations are there, they have to be seen and appreciated in terms of certain society. So, if a compensation, say for example, after 20 years to be awarded in a specific case, uh, the same before 20 years, if it is applied, uh, it's not like that. Our whole world of compensation and damages is changed with time. Gradually we are evolving, increasing the quantum, increasing the liability, increasing the obligation. Understanding and imposing of obligations is gradually getting tougher and tougher, and this is because it has a close connection with society. So, if you recall, Chairman Railway Board versus Chandrima Das, and railway board and railway station and the government's responsibility for so-called rape uh, in a guest house or railway station. Liability gradually got changed over the years and decades. We are evolving, and this evolution is because our sense of society is gradually changing with more information, knowledge, wisdom, and training. The human rights issues are getting lesser, lesser in the sense that now people are more, ready to accept the realities. uh, आज से 30 साल पहले जो हमारी सोसाइटी में मैरिजेस और इंटर कास्ट मैरिजेस और इंटर रिलीजियस मैरिजेस का एक्सेप्टेंस इतना नहीं था जितना आज हो चुका है, क्योंकि लोगों के अपने माइंड से चेंज हो रहे हैं, इसलिए आज इंटर कास्ट मैरिजेस ज्यादा हो रही हैं, एक्सेप्टेबिलिटी बढ़ रही है। तो इसलिए कोई भी वायलेशन का इशू जो 30 साल पहले जिस नजर से देखा जाता था वो आज उस नजर से बदल गया है। तो सोसाइटी से तो हर वायलेशन का एक अपनी सोसाइटी से बड़ा लेना देना होता है। यस
Sir, next question from our participant Ahmad Aman. He's asking, saving of human rights from human right law is in present scenario. So, what is your opinion and approach regarding this?
on what?
So, saving of human rights from human
So
right law. Yes, sir. In
okay,
present scenario. Yes, sir.
saving of human rights from the point of view of new legislations.
Yes, yes, sir.
Is this the question? I mean, new
Yes,
laws
sir.
on human rights and how to protect and save the human rights violations. Yeah, I think this
Yes,
is
sir.
the question. All right.
Yes, sir.
So if you look up to international instruments, conventions, and agreements, particularly UN Charter and UN Declaration and covenants, civil and political, to economic, social, cultural, to domestic human rights legislations in most of the legal systems. The effect of these, laws and the way these are to be interpreted and applied, that is gradually changing. It is changing in the sense that there are more prompt, efficient, and qualitatively more skilled forensic and other kinds of tools of investigation of these, violations today, with more of technology coming down these decades. So investigation has become, in terms of quality, a little better than it was, say, 4 decades before, whether it is a national institution or international institution or fora. When the quality of investigation has been better, today we have more specialized hospitals for investigating the facts, more, what we call medical kits for looking into the violations, body violations particularly. So the kits are evolving, and with the kits, medical kits, the investigation and the report on the basis of which the judicial institutions are supposed to work and deliver justice. Every kit is coming with the newer sense of protocols of investigation. Protocols of investigation basically deals with when a violation comes before any, doctor, or for that matter before any medical team, what should be their approach of, medical investigation. What has to be first, what is second, what is third, steps of medical analysis. So every day our systems are having more better tools and more better set of regulations coming for what we call protocols of medical kits and examination of the victim. So qualitatively better investigation results and more chances of enforcement, execution, punishment, and rehabilitation and compensation packages.
Thank you, sir. Sir, the
Thank you.
next question from Akhlaqul Azam. The question
Yes.
is, sir, do you think that the appointment of office bearers of Human Rights Commission should be done by a collegium system like higher judiciary so that government influence could be avoided?
Mhm. Mhm. As to the commission and who should be donning the position in the commission, the to presume that collegium, our collegium is also full of people from having different social mind and makeup. It's not that they are fully neutral people. That is why we are asking for a proper representation of all concerned, even in the collegium. So most of the time, the collegium is full of male people, the female people missing. Most of the time, the collegium is missing in terms of caste or other social groups and their representation. So many issues they come up. For example, Justice Karnan's issue, if you recall. So collegium is also suffering allegations. People who are ready to raise fingers upon the collegium and its constitution. So I mean, collegium is also no solution. The solution is that the commission, whatever commission and the institution which is sending the people for sitting in the commission, that commission and the people who can sit over there, the social composition must be reflected, whether it is done by the government or whether it is done by the collegium. This is not very meaningful. कोलिजियम में कोई सब बहुत हर तरह का सोशल रिप्रेजेंटेशन और वो है जेंडर रिप्रेजेंटेशन है मिसिंग है. हमारा कोलिजियम भी तो उस पे भी तो बहुत से बायस और एलिगेशंस लगते हैं, इसलिए वो भी कोई सोल्यूशन नहीं है. सोल्यूशन ये है कि जो कमीशन में जो लोग जाएं वो हमारी सोशल रियलिटी के डिफरेंट क्लासेस का वहां पे एक प्रॉपर रिफ्लेक्शन दिखता हो. महिलाएं भी हों, पुरुष भी हों, सवर्ण भी हों, दलित भी हों, तब जाके ये ह्यूमन राइट्स कमीशन एक प्रॉपर ढंग से फंक्शन कर सकता है. तो बात ये नहीं है कि मिस्टर ए कमीशन में आदमियों को भेजें या बी भेजें. बात यह है कि जो आदमी भेजे जाए वो हर सोशल कंपोजिशन के भेजे कोई भी. यस.
Sir, next question of Amit Shukla. Sir,
यस.
he's asking, justice and injustice is itself a thought of humanity. Then how can we truly understand that on the very root what the justice actually is?
You see that you are asking about the idea of justice,
Yes,
and
sir. Yes, sir.
idea of justice changes with times, and it changes with times. So the first factor is the chronology. So what was the sense of justice in 90s is not the same of sense of justice that we have in 2021. The sense of justice has changed with time. sense of justice also changes with the issues of violations. So there is no cut and dried solution, a ready-made formula to be applied in all situations. You know, the composition, the variable content of violations, this has to be investigated. Then accordingly, whatever the flavor and the content is there in a specific kind of violation, accordingly sense of justice to be differently picked up and applied in different situations. कोई एक सेट और प्रिंसिपल नहीं है जिसको हर एप्लीकेशन में हर वॉयलेशन के इशू में फिट इन कर दो और जजमेंट दे दो। वो वॉयलेशंस के नेचर और उसके वेरिएशन पर डिपेंड करता है कि कौन सी थ्योरी अप्रोप्रिएट होगी किसी स्पेसिफिक केस में। इसलिए सेंस ऑफ जस्टिस चेंज हो रहा है और सेंस ऑफ जस्टिस एक ही साल के भीतर अलग अलग सिचुएशंस में अलग अलग थ्योरीज की डिमांड करता है।
Okay, thank you, sir. Now,
Thank
I
you.
would like to invite Dr. Shikha Mishra to address the vote of thanks. Over to
Thank
you,
you.
ma'am.
Yes, sure. Good afternoon, everyone. Myself, Dr. Shikha Mishra, Assistant Professor, Tirthankar Mahavir University, feel great honor and pleasure to deliver vote of thanks on behalf of Integral University. I am very much thankful towards Integral University for giving me such an opportunity. I extend a very much thank to our learned speaker for the valuable session. Truly, the lecture was very much exhaustive and would enrich the participants. Thank you so much, sir, once again for giving your precious time. I also express thanks to participants for being a part of this event. Last but not the least, I pay thanks to all the authorities, Chairperson FDP, Dr. Naseem Sir, Convener Dr. Zunaid Beg, and coordinator Ms. Chipra for organizing this wonderful event and for assuring maximum participation. Thank you. Thank you so much.
Thank
Thank
you,
you,
Thank you
ma'am.
so
Dr.
much, sir.
Seema, Dr. Seema, and it's nice and wonderful to see that these institutions, new institutions, are doing so wonderfully well. My
Thank you, sir.
congratulations. See
Thank
you.
you, sir.
All the
Thank
Thank
best.
you.
you.
Bye.
Thank you once
Bye.
again, sir.
Namaskar, sir.
Bye. Bye.